My mother-in-law called me a gold digger, then her son signed a prenuptial agreement she never read. My mother-in-law called me a gold digger while standing beneath a chandelier my company had paid to restore. She did it at our engagement dinner, in front of 42 guests, 3 waiters, and the portrait of her late husband that dominated the ballroom of Hale House. Vivian Hale did not raise her voice. She had spent her entire adult life learning how to make cruelty sound like concern. She lifted her champagne glass, smiled toward her son, and said she hoped Ethan understood that love should never be confused with access to a family fortune. Nobody looked at me immediately. That was the worst part. They examined their plates, the flowers, and one another, giving me the privacy people offer someone whose humiliation they intend to discuss later. Ethan reached for my hand. I let him take it, although every instinct I had developed in boardrooms told me not to accept comfort from a man who had failed to interrupt the attack. Vivian continued. She said she had watched too many ambitious women attach themselves to successful families. She said a sensible bride with honorable intentions would welcome a prenuptial agreement. Then she looked directly at me and described the document as a simple precaution against misunderstanding. I asked whether she had brought a copy. That surprised her. Vivian had expected tears, anger, or a defensive declaration that I did not care about money. Instead, I requested the paperwork. Her smile sharpened. She had 3 copies waiting in her study. What Vivian did not know was that Hale House no longer belonged to the Hale family. 4 months earlier, a preservation trust had bought the property after Hale Development defaulted on 2 loans. The buyer was listed through a holding company, and the holding company belonged to me. I had approved the restoration budget, including the chandelier, because Ethan loved the house and because I believed preserving a place did not require preserving every lie told inside it. I had not hidden my finances from Ethan. He knew exactly who I was and what I owned. I had hidden them from his mother because she had never asked a question about me that was not designed to confirm an answer she already preferred. Vivian believed I was a salaried risk consultant from an ordinary family. That description was technically true. I drew a salary from North Star Forensics, the infrastructure and financial risk company I had founded 12 years earlier with 2 engineers and a borrowed conference room. What she did not know was that North Star had grown into a private firm with offices in 9 cities, that I still owned 58% of it, or that the quiet woman she dismissed as an employee had spent the previous year advising the banks trying to keep Hale Development alive. I followed her into the study after dinner. The prenup sat in a cream folder on her husband's old desk. Colored tabs marked the signature pages. Vivian explained that the family attorney had prepared it, that the terms were standard, and that delaying the wedding would be unfortunate, but preferable to proceeding without protection. Ethan stood beside the fireplace looking ill. I read the first 8 pages while Vivian watched me. It was not a standard agreement. It treated every asset Ethan might someday inherit as his separate property, while defining much of my future income as marital property. It required me to waive support regardless of the length of the marriage, surrender any claim to appreciation created by my labor, and leave any home owned by a Hale entity within 30 days of separation. One clause allowed Ethan to transfer marital funds into family businesses without my consent. Another required confidential arbitration before a panel chosen from a list maintained by Hale Development's law firm. The document was not protection. It was a trap, written by people who assumed I had nothing worth protecting. I closed the folder and told Vivian that Ethan and I would each need independent counsel. She said the family attorney represented the agreement, not either individual. That sentence was legally meaningless, and the attorney's absence from the room suggested he knew it. I told her my lawyer would respond. Vivian leaned back in her husband's chair. She said there was nothing to negotiate. I looked at Ethan. Until that moment, the prenup was not the real test. He was. Ethan had spent years surviving his mother by turning conflict into weather. He could not stop a storm, he believed, so he waited for it to pass and cleaned up quietly afterward. That habit made him gentle in ordinary life and dangerously passive when courage was required. I loved him, but love had not made me blind to the possibility that I was about to marry a man who would always ask me to absorb the damage his mother caused. He picked up the folder and removed it from the desk. Then he told Vivian the wedding would be postponed before he allowed me to sign that version. It was only 1 sentence, but it changed the room. Vivian's face did not collapse. It became still. She had built her authority on the certainty that Ethan might evade her, disappoint her, or secretly disobey her, but would never openly choose someone else. We left with the unsigned copies. In the car, Ethan apologized. I told him an apology would matter only if it changed what happened next. He did not argue. He admitted that his mother had mentioned a prenup months earlier and that he had hoped she would lose interest. He had not read the draft before dinner. Avoidance had allowed her to turn our engagement into an ambush. I told him I was willing to sign a fair agreement. In fact, I wanted one. Marriage joined lives, but it did not have to erase accountability. I also told him that I would not marry him if protecting our relationship remained my job alone. For the next 6 weeks, Ethan did something I had rarely seen him do. He stopped explaining his mother and started setting boundaries. He hired an attorney named Miriam Cho, who had no connection to Hale Development. I retained my longtime counsel, Nadia Patel. We exchanged complete financial disclosures. Ethan learned details I had previously summarized rather than itemized. My ownership in North Star, the apartment buildings held by my investment partnership, the patents licensed through a research subsidiary, and the trust that had purchased Hale House. He stared at the schedule of assets for a long time. Then he laughed once, not because the numbers were funny, but because his mother's accusation had become so absurd that laughter was the only response that did not feel bitter. Ethan's finances told a different story. He earned a good income as an architect, but most of the wealth Vivian described as his existed only as expectation. The shares his father had left him in Hale Development were non-voting, restricted, and pledged as collateral against a revolving credit facility. A family trust covered certain expenses, but Vivian served as trustee. Ethan owned a small condominium, retirement savings, and a design studio he had built himself. He was comfortable. He was not an heir sitting on a mountain of liquid wealth. More disturbing were 3 contingent guarantees listed in records provided by Hale Development. Ethan did not remember signing them. The signatures looked like his. The dates corresponded to annual family meetings where Vivian routinely placed stacks of documents in front of him. Ethan remembered signing attendance acknowledgments and shareholder consents. He did not remember guaranteeing millions of dollars in company debt. Miriam asked Hale Development for the original instruments and the related board minutes. The company's counsel delayed. Vivian called Ethan and accused me of turning a romantic precaution into a hostile audit. That accusation told me more than the documents had. Nadia proposed a reciprocal agreement. Each of us would keep premarital assets and their appreciation. Joint assets would be divided fairly. Neither spouse would be liable for the other's family obligations without separate written consent and independent legal advice. Any guarantee exceeding $50,000 would require full disclosure to both spouses if marital property could be affected. Undisclosed liabilities would remain the sole responsibility of the person who created or concealed them. Miriam added a clause designed specifically for the problem hiding in Ethan's records. If a family-controlled entity requested either spouse's signature, collateral, guarantee, or investment, the requesting entity would have to provide audited statements, current debt schedules, related party transactions, and beneficial ownership records. Failure to disclose would create a presumption of fraud between the spouses and prohibit use of marital property. The clause did not control Vivian or Hale Development directly. A prenup could not bind people who were not parties to it. But it controlled what Ethan and I could do with our marriage. It ensured neither of us could quietly expose the other to a family rescue disguised as routine paperwork. Ethan asked for one more provision. If anyone forged or misused either of our signatures in connection with a family entity, both spouses agreed to cooperate fully with investigators and waive no claim merely to protect a relative. Nadia called it the Sunlight Clause. Vivian called the entire revision an insult. She knew about it only in outline. Ethan told her that the agreement would be mutual and that independent lawyers were handling it. He did not send her the draft. When she demanded a copy, he refused. She reminded him that Hale family agreements had always been reviewed by Hale counsel. Ethan reminded her that this agreement belonged to the 2 people getting married. Vivian then made a mistake that would matter later. She told him he could sign whatever he wanted because the family assets were already untouchable. She believed the prenup's only purpose was to keep me away from Hale money. Once Ethan confirmed that inherited property would remain separate, she stopped caring about the text. She never asked what else had changed. Ethan and I signed the final agreement in Nadia's conference room 4 weeks before our wedding. We signed separate acknowledgments confirming full disclosure and independent advice. Every schedule was initialed. The meeting was recorded with our consent. Miriam asked Ethan directly whether anyone had pressured him. He said the only pressure had come from his mother, and that pressure had convinced him why a fair agreement was necessary. I watched his hand as he signed. There was no hesitation. The wedding was smaller than the engagement dinner. Vivian attended in silver, smiled for photographs, and told guests that sensible families handled money before emotion could become expensive. She assumed she had won. For the first 2 years of our marriage, the prenup remained where good agreements belong, in a secure file, almost forgotten. Ethan opened a second architecture studio and developed a reputation for converting neglected industrial buildings into affordable workspaces. North Star expanded into cyber risk after a series of attacks on municipal utilities. We bought a house together, each contributing equally, and filled it with furniture chosen for comfort rather than pedigree. Vivian visited rarely. When she did, she studied the rooms as if searching for evidence that I had spent her son's inheritance. She never acknowledged that my income paid half the mortgage, or that Ethan's company had grown partly because I had introduced him to clients who respected his work. At family events, she continued to refer to me as practical, ambitious, and fortunate. Those words were not compliments in her vocabulary. She mentioned the prenup often enough that I understood it had become a private reassurance. In her version of our marriage, I remained a threat that had been successfully contained. The first sign of Hale Development's real trouble arrived during our 3rd year of marriage. Ethan received a packet by courier marked as an annual shareholder consent. Vivian's assistant asked him to sign before the end of the day. The packet was 91 pages long. Buried on page 74 was a personal guarantee for a new loan facility of $12 million. It referenced an attached debt schedule, but the attachment was missing. Before our marriage, Ethan might have signed the last page and returned it. Instead, he sent the packet to Miriam and told Vivian he would respond after receiving the disclosures required by our agreement. Vivian came to our house that evening. She did not know I was home. I was working in the library with the door partly closed when she entered the kitchen and began telling Ethan that marriage had made him suspicious. She said the guarantee was symbolic, the bank required family unity, and no lender would ever pursue him personally. Ethan asked why the debt schedule was missing. Vivian said accountants complicated simple matters. He asked why Hale Development's chief financial officer had resigned 2 weeks earlier. She said the man wanted to spend more time with his children. The former CFO was 51, recently divorced, and had no children. Ethan declined to sign. Vivian's response was not immediate anger. She became tender. She spoke about his father, the responsibility of carrying a family name, and the employees who depended on them. Then she said, I could never understand because I had married into the story instead of inheriting it. I stepped into the kitchen and told her I understood debt very well. She looked at me as if furniture had spoken. I explained that a symbolic guarantee did not exist. A lender either had recourse or it did not. If Hale Development wanted Ethan to assume $12 million of risk, it could provide audited statements. Vivian asked whether I was advising her son against his family. I said the missing pages were advising him. She left without saying goodbye. Within a month, Hale Development provided a limited package. It showed declining revenue and several delayed projects, but the numbers were polished enough to suggest survivable strain. What it did not show were related party loans, pending claims, or the identities of several vendors receiving unusually large payments. Miriam declared the disclosure incomplete. Ethan again refused to sign. That was when the pressure spread beyond him. Vivian called my office and requested a private meeting. She arrived wearing navy wool and the expression of someone prepared to offer mercy. She said family conflict had gone too far. She acknowledged that Hale Development faced a temporary liquidity problem and suggested North Star invest in a preferred equity round. She still did not know that I controlled North Star. She believed I was a senior employee with influence over its investment committee. I asked what collateral supported the round. She said Hale properties were worth hundreds of millions. I asked for a current appraisal. She said family reputation should be sufficient. I asked about the vendors missing from the disclosure. For the first time, her composure shifted. She wanted to know how I had heard about them. I told her any competent investor would ask the same question. Vivian leaned forward and said this was my opportunity to prove I had not married Ethan for what his family could provide. If I helped save the company, perhaps people would finally understand my intentions. The logic was breathtaking. She had called me a gold digger for wanting nothing, and now she demanded millions as proof that I wanted nothing. I declined. 3 weeks later, a photograph of me appeared in a society blog under a headline about tension inside one of the city's oldest development families. The article described me as a former consultant whose marriage had isolated Ethan from his mother. An unnamed family source suggested I had pushed him to withhold support during a routine refinancing. The article also claimed I had demanded changes to the family prenup shortly before the wedding. That detail could only have come from Vivian. Ethan wanted to issue a statement. I advised against it. Public arguments reward the person willing to lie most often. Documents were slower, but they endured. We did, however, begin collecting everything. Miriam obtained the original guarantees Ethan supposedly signed before our marriage. 2 were notarized by a Hale Development employee whose commission had expired months earlier. 1 signature contained a hesitation in the first stroke that did not appear in any verified sample. The metadata on the scanned files showed they had been created years after the dates printed on them. Nadia retained a forensic document examiner. I asked Northstar's conflict committee to appoint an outside firm so that my company would not touch the investigation. Every step had to remain clean. Ethan struggled with the possibility that his mother had forged his name. He could accept manipulation because it was familiar. Fraud required him to reinterpret childhood memories he had protected as complicated love. He remembered his father's last year, when Hale Development expanded too quickly and creditors began calling the house. He remembered Vivian placing documents beside his hospital bed, telling him that routine signatures would preserve what generations had built. Ethan had been 26, grieving in advance, and desperate to be useful. The disputed guarantees began during that period. One evening he told me he no longer knew which choices had been his. I told him that was exactly why the choices he made now mattered. We did not confront Vivian, not yet. The company's crisis accelerated. Contractors filed liens. A hotel project stopped paying subcontractors. 2 lenders refused to extend maturities. Hale Development announced a grand centennial gala intended to reassure investors and celebrate 100 years of family stewardship. Vivian asked Ethan to attend as the future of the company. He agreed, but only after she promised there would be no documents and no financial announcement involving him. She promised. The gala took place at Hale House. By then, the Preservation Trust had completed the roof, restored the ballroom, and converted the unused West Wing into offices for arts organizations. Vivian continued hosting family events there under a lease negotiated before she knew who owned the buyer. She told guests the estate remained in Hale hands. I had never corrected her because ownership was less important to me than the work being done inside the building. That night, however, every hidden structure was about to become visible. Vivian seated Ethan at the head table beside her. I was placed 3 tables away near the service corridor, between a retired judge and a donor who spent dinner asking whether I still traveled for work now that I had married well. I answered politely. At 9, Vivian took the stage. She spoke about legacy, sacrifice, and the duty of one generation to protect the next. Behind her, a screen displayed photographs of Hale buildings across the city. Several had already been sold. One was under court-appointed receivership. None of that appeared in her speech. Then she called Ethan forward. He looked at me before standing. I knew immediately that something had changed. Vivian announced that Ethan had agreed to assume the role of executive chairman and lead a family-backed recapitalization. Applause filled the ballroom. On the screen appeared a rendering of a new riverfront project and the logo of a special-purpose company I had never seen. The next slide listed initial capital commitments. Beside Ethan's name was $20 million. Vivian had turned a refusal into a public promise. She expected him to protect her from embarrassment by remaining silent. More importantly, she expected the audience to treat the announcement as evidence of a completed commitment, giving lenders and investors confidence before any signature existed. Ethan reached the podium. He did not thank her. He said he had made no commitment, accepted no position, and authorized no use of his name. The applause died so completely that I heard a waiter set down a glass. Vivian tried to smile through the correction. She said families sometimes finalize details after announcing shared intentions. Ethan asked for the slide to be removed. It remained on the screen. Then a man from First Provincial Bank approached the stage carrying a folder. He was not part of Vivian's performance. His expression told me he had believed he was attending a closing disguised as a gala. He asked Ethan whether the signed marital consent had been delivered separately. Ethan said there was no signed consent. The banker looked toward Vivian. She looked at me. That was the instant I understood the full plan. The $20 million commitment was not supposed to come from Ethan's assets. He did not have $20 million. It was supposed to be secured by marital property, specifically my interest in Northstar, which Vivian had finally discovered. She had not learned it from me. A financing team conducting background diligence had traced my holding companies. Instead of admitting she had been wrong about my motives, Vivian had reclassified my wealth as a family resource. The woman who feared I would reach into her family had built a transaction designed to reach into mine. Nadia was already moving from the back of the ballroom. Ethan had invited her without telling Vivian, because the promise of no documents had sounded like another reason to expect documents. The banker opened his folder. Inside was a spousal consent bearing my name. I had never seen it. My signature appeared above a notary seal. Vivian told the banker there had been an administrative misunderstanding and that everything could be clarified privately. Nadia asked him not to remove the document from the room until its custody could be recorded. The retired judge beside me stood and offered to witness the exchange. Guests began lifting phones. Vivian ordered the screen turned off. When it finally went black, the reflection in it showed her standing beneath the restored chandelier, one hand gripping the podium, surrounded by the evidence of a plan she had believed no one would challenge in public. I walked to the stage. Vivian said my lawyer was making a family matter unnecessarily hostile. I told the banker I had not signed the consent, had not pledged any North Star shares, and had never authorized Ethan or Hale Development to negotiate with my property. He asked whether our prenuptial agreement allowed either spouse to pledge marital assets independently. Vivian answered before I could. She said the prenup protected Hale assets from me and had no relevance to the company's financing. Nadia asked if she had read it. Vivian said she had commissioned it. That was not an answer. Nadia repeated the question. For the first time since I had known her, Vivian Hale had nothing prepared to say. She had read the ambush draft in her study. She had never read the agreement her son actually signed. Ethan told the banker that our prenup prohibited either spouse from using marital property for a family-controlled entity without independent consent and complete financial disclosure. He explained that the required disclosures had been requested and refused. He also stated that the forged consent triggered our agreement to cooperate with investigators. The banker closed the folder. The proposed financing ended in that moment, although the consequences were only beginning. Vivian stepped away from the microphone and told Ethan that he was destroying his father's company. He answered that forged signatures had done that. We left the ballroom together. By midnight, the bank's legal department had frozen the transaction and notified its fraud unit. By morning, 2 other lenders requested copies of every guarantee associated with Hale Development. The original spousal consent was transferred to outside counsel under a documented chain of custody. The gala photographs spread online, but not in the way Vivian intended. The society blog that had portrayed me as an ambitious outsider published a follow-up describing a disputed pledge and a public family confrontation. It still got several facts wrong. This time, I did not care. The facts that mattered were moving through offices where evidence outweighed reputation. Vivian called Ethan 31 times over the next 2 days. He did not block her. He saved every voicemail. In the first messages, she blamed the banker, then Nadia, then me. By the 15th call, she admitted that the consent had been prepared by Hale Development's general counsel and insisted she believed I had authorized it through Ethan. By the 23rd, she said the document was merely a placeholder that was never intended to be used until properly signed. In the final messages, she begged Ethan to remember that criminal scrutiny would destroy hundreds of employees. Each version contradicted the last. Ethan gave the recordings to Miriam. The forensic examination of the consent found that my signature had been copied from a vendor agreement North Star signed years earlier. The notary seal belonged to the same former Hale employee connected to Ethan's old guarantees. That employee, Leonard Price, had become the registered owner of 3 vendors receiving unexplained payments from Hale Development. When investigators interviewed him, Leonard asked for immunity. His account exposed a system that had existed for almost a decade. Vivian moved money through consulting companies controlled by loyal employees, using inflated invoices to cover operating shortfalls and personal expenses. When lenders required stronger guarantees, documents were backdated or signature pages were reused. Some transactions began as temporary measures during her husband's illness. Temporary measures became habits, and habits became the company's real operating system. Vivian had not stolen a fortune and hidden it offshore. The truth was more ordinary and, in some ways, more destructive. She had spent future money to preserve the appearance of present wealth. Hale House events, private travel, charitable pledges, and failing prestige projects were financed with debt. She used new loans to conceal old losses, then blamed markets, contractors, and disloyal executives when the numbers refused to obey her. The company was not a treasure chest threatened by a gold digger. It was a collapsing stage set, and Vivian had been stealing lumber from the supports to keep the front polished. The investigation did not make Ethan feel vindicated. It made him quiet. For several weeks, he woke before dawn and sat in the kitchen reading old financial records. He was not trying to build a defense for Vivian. He was looking for the moment when he should have understood. Children of controlling parents often believe awareness should have arrived like a fire alarm. In reality, it comes as a series of details that were each survivable alone. A signature requested during grief, an explanation that changed slightly, a question punished as disloyalty. Ethan found an email he had sent his mother 6 years earlier, asking why a bank confirmation listed him as guarantor. Vivian had replied that the bank used standard language and that the company's lawyers would correct it. He had accepted the answer because accepting it preserved the relationship he thought he had. He showed me the email and said he had been weak. I told him trust was not weakness. Refusing to act after trust was broken would have been. That distinction mattered to both of us. Our marriage did not survive because the prenup contained a clever clause. It survived because, when the clause forced a choice, Ethan chose truth over family theater. A contract could draw a boundary. It could not make someone stand on the correct side. Hale Development entered restructuring under court supervision. An independent chief restructuring officer replaced Vivian, whose authority was suspended by the board after lenders presented the forged documents. Projects that could survive were separated from those created only to generate fees and publicity. The riverfront company announced at the gala had no land, no permits, and only a preliminary option that expired days later. The $20 million commitment beside Ethan's name had been necessary because Vivian needed a credible anchor investor. Once outsiders believed her son and his wealthy wife had committed, she expected smaller investors to follow. Their money would have paid the most urgent creditors, creating just enough time to seek another loan. It was not a rescue plan. It was a delay purchased with other people's confidence. Vivian's lawyers argued that she had relied on staff and did not understand how the consent was prepared. Leonard Price produced messages in which she instructed him to use the clean Claire signature from North Star and make the page match the bank's format. Another message told him Ethan would bring her around once the family commitment is public. The words removed the last possible ambiguity. Ethan read them in Miriam's office. He did not cry there. He waited until we reached the parking garage, then leaned against the passenger door as though his body had forgotten how to carry its own weight. His mother had not merely expected him to forgive her. She had planned to use his love for me as leverage against both of us. She believed public pressure would make him pressure me, and that I would surrender rather than embarrass him. For years, Vivian had mistaken affection for a weakness because she understood relationships only as channels of control. The prenup prevented the financial harm, but it also documented exactly how wrong her assumptions were. Schedule A showed that my North Star ownership predated the marriage. Schedule D listed the procedures required before either of us could pledge assets. The recorded signing established informed consent. Ethan's attorney had sent written notices rejecting the guarantee months before the gala. There was no plausible path by which Vivian could claim confusion. She had designed the first agreement to leave me powerless. The fair agreement she ignored left her without a lie large enough to cover the evidence. Her first formal response was to sue Ethan. Acting through the family trust, Vivian claimed he had breached fiduciary duties by refusing to support Hale Development and cooperating with lenders. She sought to remove him as a beneficiary and recover losses allegedly caused by his public statement at the gala. The complaint portrayed the company as healthy before Ethan spoke. Attached to it was an internal valuation showing assets far greater than liabilities. That valuation opened another door. It listed Hale House as a corporate asset worth $18 million. Nadia compared the exhibit to county records and the restructuring filings. Hale Development had sold the property to the Preservation Trust months before our wedding. The sale proceeds had been used to pay a secured lender. Yet Vivian continued representing the house as company collateral in documents signed long after the sale. During discovery, her attorneys demanded information about my relationship to the trust. We disclosed it. Vivian learned I owned Hale House through a filing in the lawsuit she had brought against her own son. She called me directly for the first time since the gala. Her voice was almost calm. She asked when I had planned to tell the family that I had taken their home. I reminded her that Hale Development sold it voluntarily after defaulting on loans. The trust paid market value, preserved the building, assumed the restoration cost, and allowed family events to continue under a lease. Nothing had been taken. She said I had let her entertain guests in a house I secretly owned because I enjoyed humiliating her. The accusation revealed how she would have used the information if our positions were reversed. I had kept the ownership private because the trust's work did not require applause, and because Ethan deserved time to separate his memories of the house from his mother's claims about it. I told Vivian that the building was safer, its creditors had been paid, and its public rooms were now accessible to community organizations. Ownership had changed. Its useful life had not ended. She asked whether I understood what the Hale name meant in that city. I looked through my office window at 3 blocks of affordable housing North Star's risk team had helped a nonprofit finance. I thought about unpaid subcontractors, copied signatures, and employees told their livelihoods depended on silence. I said I understood exactly what her version of the name had cost. Then I ended the call. The trust lawsuit failed quickly. The court found that Ethan's duty as a shareholder did not require him to guarantee company debts, conceal suspected fraud, or expose marital assets. Vivian's attempt to remove him as a beneficiary also failed because the trust instrument limited removal to defined misconduct, none of which included refusing a loan. More importantly, discovery in the civil case moved records to criminal investigators. The prosecutor charged Vivian with conspiracy, bank fraud, identity theft, falsifying business records, and attempted theft by deception. Leonard faced related charges under a cooperation agreement. Hale Development's former general counsel was charged after billing records showed he prepared multiple false certifications. Vivian surrendered through a side entrance at the courthouse. She wore the same navy coat she had worn when asking North Star to invest. I did not attend. Revenge stories often compress consequence into a single public moment. Real consequence is administrative. It arrives through calendars, subpoenas, frozen accounts, postponed hearings, and envelopes that must be opened even when your hands shake. It occupies years, not minutes. The hardest part was deciding what responsibility we had toward people who had not participated in Vivian's fraud. Hale Development employed more than 400 people directly and supported hundreds more through projects. Some senior managers had helped conceal records. Most employees had simply gone to work inside a company whose public confidence hid private panic. The restructuring officer contacted North Star about evaluating unfinished projects. I recused myself from the engagement because of the family connection, but our independent committee accepted under strict conditions. A separate team assessed which sites could be completed safely and which contracts needed renegotiation. Ethan's studio joined a consortium bidding to redesign 2 stalled properties. He did not receive special access. In fact, he insisted on a blind technical review because he knew any success would be described as another family favor. His consortium won one project and lost the other. The one they won became a mixed-use development with affordable studios on the upper floors and a union training center at street level. It was smaller than Vivian's original luxury concept and far more useful. I purchased several secured claims through a fund managed independently from North Star. The fund provided completion financing only after the old equity was wiped out and a court-approved new governance. Vivian later called this proof that I had planned to steal Hale Development all along. In reality, I did not acquire the company. No single family did. Creditors, employees, and new investors received interests under a restructuring plan. The Hale name was removed from the surviving business because lenders considered it a liability. Ethan chose not to seek control. That decision confused reporters and enraged Vivian. She believed refusing the throne proved I controlled him. She could not imagine that he simply did not want to inherit a system built on obligation and secrecy. He kept his architecture studio. He kept the memories of his father that remained true. He let everything else be examined. Our marriage changed in less visible ways. For a long time, Ethan apologized whenever a letter arrived from one of Vivian's lawyers. I finally told him that his mother's conduct was not a debt he owed me. I did not need lifelong penance. I needed partnership. We returned to counseling, not because we were failing, but because surviving a crisis can create habits that later become their own damage. During the investigation, every dinner had turned into a strategy meeting. Every unknown number felt dangerous. We had become excellent at defense and uncertain how to rest. We learned to spend evenings without discussing Hale Development. We planted trees behind our house. Ethan built a reading bench that was slightly crooked because he refused to measure twice when making something for himself. I learned that letting another person care for me did not reduce my independence. The prenup remained valid. Neither of us wanted to tear it up as a romantic gesture. Its fairness was part of what made it unthreatening. It protected his studio, my company, and the life we built jointly. More than that, it reminded us that love and clarity were not enemies. Vivian offered a plea 18 months after the gala. She agreed to plead guilty to conspiracy to commit bank fraud and aggravated identity theft. Several charges were dismissed under the agreement, but restitution remained substantial. The sentencing memorandum documented false guarantees totaling more than $30 million, although not all had produced losses. The attempted pledge of my North Star shares was described in detail. Her attorneys submitted letters from friends who praised her philanthropy, loyalty, and devotion to preserving the city's history. Many letters mentioned events at Hale House. None mentioned that the charities had sometimes waited months to receive money promised publicly. Vivian asked Ethan to write on her behalf. He spent 3 days considering it. In the end, he wrote a letter, but not the one she wanted. He told the court that his mother was capable of generosity and that punishment would not restore every broken relationship. He also described the years of manipulation, the false documents, and the pressure placed on employees. He asked the judge to consider the people harmed rather than the reputation she had maintained. He sent Vivian a copy before filing it. She replied that I had finally succeeded in taking her son. Ethan did not answer. At sentencing, the judge said a respected name did not reduce culpability when respect had been used to make scrutiny less likely. Vivian received a prison term shorter than prosecutors requested and longer than she expected. She was ordered to pay restitution, surrender assets obtained through the fraudulent schemes, and remain barred from managing companies during supervised release. The court did not order her to apologize. Courts can compel money and movement. They cannot compel understanding. Afterward, reporters waited on the courthouse steps. One asked me whether the prenup had saved my fortune. I said it had protected our marriage from a fraudulent transaction, but a document had not saved us. Ethan's decision to read, question, and refuse had done that. The shorter answer would have made a better headline. The longer answer was true. Vivian served just over 3 years. During that time, Hale House changed again. The Preservation Trust opened the restored West Garden, created an archive of construction records, and established a paid apprenticeship program for students entering conservation trades. We did not erase the Hale name from the building. History becomes propaganda when only flattering names remain. We did, however, correct the plaques. The new exhibit explained the original family's contributions, the company's later collapse, the sale, and the workers who restored the property. Vivian had spent years presenting legacy as something inherited whole. The archive showed it as a series of choices, some admirable and some ruinous. Ethan visited the house for the first time after the criminal case ended. We walked through the ballroom alone before a community concert. The chandelier glowed above us. He remembered hiding beneath a table during formal dinners and watching his father dance badly at a Christmas party. He also remembered the gala, the false pledge, and his mother's face when Nadia asked whether she had read the agreement. He said the room felt smaller. I told him rooms often do after we stop being children inside them. He asked why I had bought the house when my advisors warned that restoration would be expensive. The answer was complicated. The property was historically important. The trust's mission fit the project. The purchase price was fair. But there was also a personal reason I had been reluctant to admit. On our third date, Ethan had brought me to the garden wall after midnight because he wanted to show me the stone carvings his grandfather repaired by hand. He had spoken then not about ownership, but workmanship. I bought the house months later because I believed the best part of what he loved could survive without belonging to his family. That did not make the acquisition a gift to him. It made it an investment in the difference between legacy and possession. Vivian returned to the city after her release and moved into a modest condominium owned by a cousin. Her remaining wealth was far less than people assumed, though she was not destitute. She gave no interviews. Through an attorney, she requested permission to hold a private family memorial at Hale House on the anniversary of her husband's death. The trust board approved the request under the same terms offered to other private groups. I did not attend. Ethan did. He told me later that Vivian looked older but not transformed. She thanked him for coming and spent most of the hour discussing people who had abandoned her. She never mentioned the copied signatures. She referred to the criminal case as the business disaster and described her plea as something she accepted to protect others. Before leaving, she asked whether I still had him sign papers before making decisions. Ethan told her the prenup had been his decision. Vivian said she had only wanted to protect him from me. He told her that if she had read the final agreement, she would have known it protected both of us from people willing to use love as collateral. Then he left. That conversation did not reconcile them. It established the only relationship he was willing to have, one in which truth was not negotiable for access. Years after the engagement dinner, I found one of Vivian's original prenup drafts in a box of old wedding materials. The cream folder still held its colored signature tabs. Reading it no longer made me angry. It felt like an artifact from a civilization built around a mistaken idea of power. Vivian had assumed wealth belonged to the person who appeared most entitled to it. She thought marriage was a border crossing, women like me were invaders, and legal documents were walls constructed by whoever hired the lawyer first. The agreement Ethan signed was powerful for the opposite reason. It required both of us to disclose, consent, and remain responsible for our own choices. It did not assume one spouse deserved protection and the other deserved suspicion. It recognized that secrecy, not intimacy, was the greater threat. I shredded the old draft. I kept the final agreement. North Star eventually went public through an employee-centered structure that preserved voting control among long-term owners. The financial press estimated my net worth in numbers that would have stunned the guests at our engagement dinner. By then, the estimate mattered less to me than the fact that hundreds of employees received equity through the offering. Ethan's studio grew slowly and remained his. He designed public buildings, training centers, and housing conversions. When journalists described him as the hale heir who rejected his family empire, he corrected them. He was an architect. His work did not need a ruined company to make it significant. We never had the kind of marriage Vivian understood. There was no dominant fortune absorbing the smaller one, no winner controlling the family name, and no silent spouse proving loyalty through surrender. We maintained separate accounts, joint plans, independent work, and shared responsibilities. We reviewed major documents together. We asked questions even when the answers might be uncomfortable. Once a year, usually near our anniversary, Ethan joked that we should send his mother a thank you note for insisting on the prenup. We never did. She deserved responsibility for the coercion, not credit for the fairness created in response to it. The real irony was not that the alleged gold digger turned out to be wealthier. Money alone would have made the reversal shallow. The irony was that Vivian spent years guarding an inheritance that barely existed while overlooking the debts, fraud, and fear consuming her family from inside. She scrutinized my intentions because that was easier than scrutinizing her accounts. When the truth finally arrived, it did not arrive as a dramatic revelation about my bank balance. It arrived as a question in a ballroom. Had she read the agreement? She had not. She had read the version in which I lost and assumed no other version was possible. That assumption cost her the transaction she needed, exposed the signatures she had stolen, and forced her son to choose what kind of man he wanted to become. The prenup did exactly what a good agreement should do. It did not punish marriage. It made hidden risk visible before hidden risk could become shared ruin. I sometimes think about the silence after Vivian called me a gold digger. At the time, the guests' lowered eyes felt like agreement. Now I understand that many people simply did not know what to do when a powerful person made cruelty part of the ceremony. I know what to do. I ask for the paperwork. I read every page. And I never confuse a person's confidence that they will win with proof that they understand what they signed.